Thornton, Robert Louis Thornton Jr., 25W837260. And I also have 25T644914B. Your name?
Robert Thornton Jr.
You're charged with failure to pay your fines and costs as ordered. You were supposed to pay those at the rate of $100 weekly beginning August the 4th of 25. We have a balance still owing according to probation as of the date of the show cause of $470. That's count one. Count two is that you failed to clear all your warrants by August the 25th of 25. Do you understand that?
Yes.
And you also have a no insurance charge. Does he owe, is that right, Lisa? Does he owe,
470.
how much, can you pull that up, Jennifer?
You have GIS up. Is that what I need?
Okay, that's all right. Can you tell me how much is owed on the no proof of insurance, Lisa, please?
$260.
So you owe $260 on the other case. And that means you could get 26 days. If I find you could have paid and didn't, that is, that your failure to pay was not without your fault. Do you understand that?
Yes.
And you understand all your rights on this advice of rights?
Yeah.
You read it?
Yeah.
Understood it?
Yeah.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. You understand that?
Understood.
You have the right to an attorney. Be happy to provide you with one at public expense. If you would like one, would you like one?
Yes.
I know we're not guilty plea on these. Either way, you're going to come back in front of me, okay?
Yes.
All right.
Judge, that no insurance has a misdemeanor attached to it that's in warrant status. I'll pull it right now.
Okay. Just give me 1 second.
Yeah, you need to condition the bond. You need it?
No, oh, I've got everything here.
Okay.
Yeah, I got,
Sorry,
I
you're good.
didn't see the
Okay.
probation. All right, so I'm gonna enter a not guilty plea on both of these. I'm gonna give you a lawyer. And then you're going to come back in front of me either way, okay?
It's my commentary, actually, my lawyer's here.
I'm sorry?
It's my commentary for what you were saying, like if I just didn't pay on it just because of not paying, it's the time for me to speak with the lawyer.
No, we're gonna get you a lawyer first. And then I'm probably going to give him the other file too, or her. I don't know who's doing it. I don't think Ms. Patillo's here, so at any rate, we'll give you the other file too. We'll give him the other file or her the other file, whoever's handling this. And there's going to be another file because she just told me you have a warrant out for your arrest on something else. The companion citation on this no insurance. Okay, so you can go out in the hall. He'll set you up with a lawyer and we'll go from there. Any questions?
And now I have to wait till my lawyer here.
Pardon?
No, I'll have to wait till he loads.
Yeah, you can go talk to the lawyer. We'll set you up. Thank you. Leah Boozer. 25T644894. Your name, ma'am?
Leah Boozer.
You're charged with failure to pay $213 on a child restraint charge. If you plead guilty or if you're found guilty and I find that your failure to pay was not without your fault, you could get 1 day jail for every $10 owed. So you could get 22 days. Do you understand that?
Yes,
You can satisfy that in full by payment, in full by serving the jail term, or in part by payment, in part by serving the jail term. Do you understand that?
yes,
Do you work?
no,
Can you pay this today?
no. But I was coming because my kids are too big for a car seat. My
Oh,
kids are
hang on,
8,
hang on. You went into default. I'm not gonna relitigate this case.
Okay, I got called to make a court date. Can't call to make a court date. You guys have an answer machine. And then finally, I got the court date.
And then you didn't show up, right?
This is the court.
No, this was,
I got a piece of paper.
boy, the United States Postal Service must have issues. Lisa, would you please tell me what was sent to Ms. Boozer? You still live on Robb Street?
Yeah,
Okay. Can you please tell her what was sent to her?
Yeah, we don't have a request for a court date. She defaulted August 6th. 20% late fee went on September 25th, collection letter October 1st, and then show cause November 6th.
yes. And I have been calling. You guys have the answer machine service to do a court date. I'm pretty sure you guys have me on the answer machine about 10 times.
I'm sorry, you left 10 messages?
Yes. Ever since this ticket, I've been trying to get a court date.
I'll tell you what you do. Go get your phone bill. Go get, no, I want to see the calls that you, just please listen.
Okay.
We don't make mistakes like that here.
Okay.
Okay? So if you want to go back and you want to get your phone bill that shows that you called the court 10 times,
Okay.
I'll be happy to set aside the default right then and there on,
Okay.
just wait a second. Right there on the spot without requiring you to file a motion and without requiring you to post a bond. Okay? So I'll adjourn this 2 weeks. You come back with your bills.
Can we do that?
Do you have your bills?
I can pull it up on my phone.
Yeah, but this is not calling in the last day or two. You were supposed to call here by, but just please listen. You were supposed to call her by July 30. Do you have proof that you called here by July 30 and set up a court date? You said you called 10 times.
Yeah.
Okay, so you go get that proof. I'll put the file right here.
Yeah.
You have a bill. Okay, go check it out. I'd love to see it. Thank you. Ms. Boozer, did you need to see me again? Hang on. I gotta call your case. Leah Devon Boozer, 25T 644-894. You got those messages for me?
We'll keep getting call records for the last 60 days.
You didn't call. Ma'am,
Judge,
yeah,
I did go through our call log while we were waiting. I do have a call from her on August 8th, which is past the due date. We left her a message with all of her options of a defaulted ticket.
Oh, I know I did.
well, they went
Thank
to,
you, appreciate that.
that was late. And then they called you. Did you hear what she said?
Yeah.
Okay, so you didn't call here 10 times and you didn't call within the time period. Why did I know that was going to happen? Listen to me very carefully.
Okay.
Be honest with me. Ma'am. You told me you called 10 times. You didn't call 10 times. You called after the due date. You were in default. They told you how to go about it and you didn't do anything. Now, I don't want to quarrel about this. I don't understand why people don't understand that you're going to get so much further with me when you're honest. I just don't like dishonesty. But that being said, let's put that aside. How much can you pay today on this?
I don't have nothing to pay today.
How are you supporting yourself? How are you supporting yourself?
I have like side jobs I do, but I don't have a job. So I can pay.
Do you have kids?
$25. Yes, I do.
Is the father in their life? Is he paying you child support? Does he work?
I don't know.
Go to the friend of the court. These guys can't have kids and then not support them. That's not the way it works in this country. You pay 25 a week, you said?
Can I pay like 25
A month.
and then whatever extra I can pay on it? How much is the total ticket?
You owe $213.
Okay.
I mean, you're asking a lot. This means it's gonna take you 9 months to pay this.
Well, I can do what I can. I'll be honest.
How old are your children?
8 and 7.
They're in school?
Yes.
Why aren't you getting a job when they're in school?
Because I just don't have.
Gotta work. You don't want to be in poverty your whole life. I'll let you do this. You pay 25 per month beginning December 1. If you don't have the money, you call the court, you go on or before any due date, the first of every month. I expect you to pay 25. Or if you can't, you either come in here, drive in here at 8:30 in the morning, and I'll give you an extension when you ask for it, or you call the court. We'll go on Zoom at 8:30 in the morning, but you can't ignore courts like this, man.
Okay.
Okay? Good.
December 1st.
This, the first of every month, starting December
Do I
1st.
get something that I know how to pay it or?
Yeah, go down the hall. They'll help you out. They're busy down there, so just be patient. Good luck. Recalling Robert Louis Thornton Jr., 25T644-914 A and B. I now have the A file and then also 25W837260. Your name?
Robert Louis Thornton Jr.
You just, it's my understanding now, you told my court officer and you just indicate here you don't want a lawyer. Is that true?
Yes, because
I don't need to hear. I just, if you want a lawyer, I'm gonna give you one. If you don't, I'm gonna push. Okay. All right, well, I already arraigned you on the two. You have failure to pay no insurance. You have failure to clear all warrants on the resist and obstruct. You also have this other file and failure to pay on that charge as well. And you also have another charge here of driving on a suspended license that I had to rearraign you on. Okay? Do we understand one another?
Yeah.
So I'm going to rearraign you on the charge. You're charged with driving on a suspended from February 11 to 25. They think you're operating a motor vehicle on King near Douglas and Trenton. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
Yes, sir.
All right. You understand all your rights.
Yes, sir.
If you plead guilty, you're going to be giving up all these rights. We're not going to have a trial then. Do you understand that?
Yes, sir.
Okay. You want me to enter a not guilty plea for you?
Yes, sir.
So you're going to go to the prosecutor on one. I don't know what you're doing here. Let's stop. Let me finish. You act like we're inviting you to a dinner party here, sir. You show up, you don't show up. This case been going on since March. February. No. You see all these red marks? See all those on there? Can you see that?
Yes, I know.
That means
I see your red, but yeah, thank you.
that's warrants. That means you weren't here. It means you didn't show up when you were supposed to be. I don't know what kind of game you think you're playing here, but you better stop it. Yes.
Speak. You're saying that I'm playing games, but I admit it. No, this is why I brought myself back in here to not have a lawyer. I don't think any of this is a game. I wouldn't be here if it wasn't.
Don't give me this holier than thou stuff.
I don't.
You don't show up, you don't take care of what you're supposed to take care of.
Okay.
I'm sending you over the prosecutor. I'm entering a not guilty plea. You missed here, just so you know. Just so you know, you missed on March 6th, March 20, July 10, August 7th.
Stay in Providence. And at the
I'm sorry?
Stay in Providence.
I don't care if you stay in Tuscaloosa. What does that have to do with anything?
Respond to your question part.
Go talk to the prosecutor on, that's going to Judge Hessen. These two are mine, and I will deal with the contempt charge on the no insurance and the probation violation on the resist and obstruct. So you go talk to the prosecutor on that one. If you still wish to waive your right to a lawyer on that, I'll send you to the prosecutor on that case. You can talk to him. And then you're going to come back in front of me on, if there's a resolution on that case, I'm going to send you to Judge Hessen. If there's not, then I'll do what I'm gonna do, set a bond. And then on these two, we're gonna go through these, talk about your violations of probation and your failure to pay on the civil infraction, okay?
Yeah, I'm still lost between the fact that you were telling me why I didn't want a lawyer, and then you're saying that I just blew everything under the water. But when I try to elaborate more on the situation,
Sure.
you're just downing everything I was saying without
Sure.
giving me the reason.
Sure.
And I don't.
This
I
is-
have a
you're in
great
a-
job. I have a career. I don't have a tedious job to where I'm jumping back and forth.
Sir,
And I have.
sir, it's the fourth quarter. There's 2 minutes to go and you're down 41-3. I don't want to hear it. Go talk to the prosecutor. This case has been going on since February. Take your attitude out in the hallway. Come on up, Mr. Thornton. Recalling Robert Louis Thornton Jr., 25T644-914B and 25W837-260. Your name? All right, so I'm going to go ahead. You have a probation violation here of failure to pay your fines and costs as ordered, 470, and failure to clear all your warrants by August 25th. And then you have, on the other case in front of me, you have a failure to pay 260. So actually it's Judge Hessen's, but I'll just go ahead and handle that. You still wish to proceed without a lawyer?
No, I wasn't able to elaborate. I want a lawyer to sign.
Pardon?
No, I want a lawyer.
Okay, no problem. We'll give you a lawyer. Go out in the hallway, get him a lawyer, John, and then you'll come back in front of me, okay? Come on up here, Mr. Thornton.
Anybody that's in person for Judge Hessen can go back down to her courtroom. She's back. If you're in person for Judge Hessen, go back down to her courtroom.
Okay,
I'll get the files and stuff.
your name.
Good morning, Judge. Manley Gates, Chairman, Deputy Phone State of
Sir, your name.
Robert Louis Thornton Jr.
All right. Okay, what do we do? I almost need to get off this bench for a minute.
Mr. Thornton's going to get on a stroke cause.
I know. What is he gonna do? He's got a case in front of Judge Hessen that he's gonna have to go in front of Judge Hessen.
Okay.
But these two, I've got a failure to pay 260, and then I've got on a probation violation on the resist and obstruct that was taken under 771. Failure to pay fines and costs of 470,
For the person.
and failure to clear all warrants by August 25th.
Yes, sir.
So how's he going to proceed?
He'll plead guilty of failure to pay.
What about, and he's gonna plead guilty also to failure to clear his warrants?
Yes, Judge.
Is that what you want to do, sir? If you do that, that would be 2 technical violations. You could get 10 days. Do you understand that?
Yes, sir.
All right. Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing. Do you understand that?
Understood.
All right. You have any questions before I ask you how you plead?
No.
And you understand if you plead on this other case, I'm talking about the failure to pay no insurance, that you could get 26 days on. You can be incarcerated 1 day for every $10 owed. You can satisfy that in full by paying the whole amount, in full by serving 26 days, or in part by payment, in part by serving jail. So you could pay 130 and only have to serve 13 days. Do you understand that?
Yes, sir.
All right, is the count one on the probation violation to the charge that you failed to pay your fines and costs as ordered, balance owing 470, how do you plead?
Yes.
Did you fail to pay on that? Anybody force you to plead guilty? Is the count two that you failed to clear all your warrants by August 25th? How do you plead?
Yes.
Did you fail to clear your warrants on this case as ordered, all of them by August 25th
Yes, sir.
of 25?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
All right, I'm gonna accept those pleas. Okay? Find those pleas made voluntarily and understandingly, and now go into the insurance to the charge you failed to pay 260. How do you plead?
Yes.
Did you fail to pay?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Boy, you came back in with a different attitude. That's good to see. All I was trying to tell you, you cannot do this. You cannot not show up. You cannot ignore court orders. I'm sure your lawyer told you not to act like that. I mean, no matter how you cut it on this case in front of Judge Heston, I'm gonna let you talk to her about it. You didn't show up. You've been playing with this case for 9, 10 months. What do you have to say? What's he doing? Does he work?
He does work, Judge. It's just been a financial issue.
Where does he work and how much does he make?
He works, he's a painter at All Face Painting, Judge. He makes about $20 an hour. However, because the work is somewhat seasonal right now, his hours have been diminished. So he only does about roughly averages about 25 hours. So he does get paid weekly, but Judge, again, after his father passed away, he became homeless. He didn't have stable residence. He's been trying to get his at least living situation together. And so it's been having to put out of pocket a lot of costs in order to do that.
He usually needs to learn some more humility. That's what he needs to learn. What do you want me to do?
We would ask the court just to allow him more time, Judge, to wrap this up, because he did assure me that he can go, if the court would allow an extension, he can catch back up and pay this off. That's what his entire intent was.
Tell you what I'm gonna do. I'm gonna set it for sentencing on the probation violation, okay? And you're gonna come up with some money. I'm gonna give you some time. I placed you on probation for 12 months, so it's not a big hurry. We're gonna set a sentencing on that in 1 month, and we're gonna set a sentencing on the no insurance in 1 month, okay? And you're gonna come up with some money. All right, you understand? And I can tell you, you better go over and surrender on those warrants too.
And that was the other issue, Judge, because of the number of warrants, in order.
How many warrants did he have?
I believe I counted 8.
No. You came in here like you were a choir boy and you got warrants all over the place.
If I may.
Yeah.
You saying that, but I'm not saying to make sure I appear, I don't have rights, I don't have no reliable.
How'd you get here today?
And I.
From where?
My stepmother's and I had our time.
Wait a minute, slow down. Where did you stay last?
True.
True.
Right in, it's about a 44-minute walk.
You want to appear on Zoom? I'll let you appear on Zoom. You know how to use Zoom?
Yes.
Lisa, let's give him a sentence date about 5 weeks out, okay? And he can come up with some money and he can get his life in order and come back with an attitude more like he has now than when he came in front of me the first time. So we could do like mid-December. How's that?
That works.
December 8th at 8:30.
That works.
Okay? Humility, right?
Yes.
Humility. I've never seen so much with people blaming the system. You know, everybody's blaming the system now. The system's horrible. The system's horrible. It's the same system we had 30 years ago. The only thing I can tell we've gotten is a lot more people that have a lot more disrespect. You're going to take this one down to Judge Heston and she'll handle that. And I'm going to do these Zoom cases here. Okay? Good luck to you, sir. Go down. Listen to me. Go down the hall, get your notices. And you're going to first go down and get your notices. Mr. Gaith will take this over to Judge Heston. And then after you get your notices, you go down and meet Mr. Gaith in the other courtroom. Okay? Who is?
That.
Okay. Sure. Yeah, hi. Is that in front of Judge Heston? What does he want? Sir, what are you carrying on about? Tell me, what's your name? No, you can't approach until I have the file. I don't even know what you're here on.
Be handed it up front.
I don't want you to be, listen, just tell me your name.
Benjamin Morris.
Are you on the docket today?
You pushed it away 2 weeks from now.
I didn't push anything away. I don't know what you're talking
I
about.
got an email from Amy Zawicki stating that the court date is put
Hang
on
on.
today.
Can somebody give?
We need a file. That's what I told him. He
Get
talked
the
to
file for me,
Maloney.
Lisa, please. Can you do that? Are you on there still? Hey, Lisa? Lisa?
I'm here, Judge. I can bring the file down.
Yeah, bring the file down. I don't know anything about it. Just relax. Take 1 second. Sit down, please.
Your Honor, I have a job interview.
Sit down. I can only move so fast. They're getting the file.
Right. I understand, Judge.
Well, are they bringing me the files or what are they doing? Yeah, I mean, I got an interpreter in here. Okay, thanks.
Peter's not in there. So
What is going on?
Some more files. There's nobody in that room. Are you trying all of them?
I'll do whatever they want, but they gotta bring them down here.
We're trying to figure it out right now.
Oh, okay, Benjamin Chester Morris, 25T643818.
All these people are on Zoom, so we gotta get them to move.
I got it. Okay, now you step up here and tell me your name, sir. Your name?
Benjamin Chester Morris. Your mother was my English teacher at St. Joe's.
That's not gonna help you. It's not gonna hurt you either, but
I'm trying to.
listen, you're raising hell down there with all these people the last few days, I'm hearing. Just calm down here. Nobody's gonna treat you bad. Hello? Yeah,
I'm light sensitive.
Okay.
okay, good enough. Good enough. I don't. No worries. Thanks. So why'd you come in early today? Your court date isn't today.
I understand that. It's trying to acquire a motion for discovery for both charges. Well, 4 charges.
What 4 charges? I only have one in front of me. It's a noise violation.
There's an additional charge.
At a
That's assigned to
Trenton?
Judge Hessen.
It's assigned to you, and I would wish to be reassigned to you because I believe you're the fairest judge.
Now, wait a second. She's fair too. Yes, she is. Stop, please. Stop. You don't get to pick who your judge is. Do we have an order granting discovery here, Lisa?
Yes, I already gave it to him, Judge.
Hand that up to me, will you please? What do you want? Tell me what you want, Mr. Morrison. Hand that up your order. I'm sorry, Mr. Morris.
It's okay. I don't have it executed and completed at this time because I've been so busy, so it's blank.
Well, tell me what you want, Phil.
Okay, so
Let me see the order granting discovery. Let me see that.
it's just a blank piece.
I know, but it says order granting discovery on it, right?
I'll pull it up, my file. I get it for you. Just relax, please. I'm not telling you to relax. It just takes me a second to go.
Well, I know, but you said, I'm trying to help you. You said you got a job interview and
I do. I got it in 22 minutes.
I don't usually call cases when they're not scheduled on my docket.
I talked to Mr. Bologna and he told me you're here now, walk right into the courtroom and talk to the court reporter. That was per his instruction.
All right, okay. Just stop giving these girls a hard time down there.
They're not professional.
No, that is not true. I'll place them up against anybody in the state. That is not true.
Well, that
is not true. Listen, don't start giving me a hard time about the staff, okay? That is absolutely not true. Hand me up what you got and I'll take a look. This is a noise violation, right? It's all it is.
That's all it is.
You're acting like it's
Any ticket that I get is important.
I understand. I just don't have people giving me discovery orders on noise violations.
Well, I already filed a FOIA for the body cam footage. And I just left Trenton Police Department. And they won't give it.
Call in, Mr. Bologna, will you?
I don't understand why they won't give it to me.
Hang on a second. Hang on. Just let me fill something out, will you? I'm gonna get you out of here. I promise you.
Thank you. I saw you on court cam one time and you told the guy you weren't gonna railroad him, and I feel like you won't railroad me.
All right. She won't either. None of us do here. We're good. We're
You're fair. That's why I voted for you.
all right. Okay. Mr. Bologna. Mr. Bologna,
Yes, Your Honor.
this is a noise violation case. He wants you want the video footage or what is it, Mr. Morris? What do you want?
anything in regards to it that I can defend myself against Mr. Bologna.
All right, but I don't know what you're asking. Is there a dash cam or is it video? Do you have anything?
I have not looked at it, Your Honor. I believe he still has to be arraigned, because that hasn't even been arraigned yet on this charge. What I've explained to him is once he's arraigned, we will submit a formal discovery order, and he will get every single thing that.
Here, I want you to sign this. Here's what I'm writing down here, okay? Any dash cam / videos regarding the incident in question.
Your Honor, if I make it.
Just wait 1 second.
No problem.
Date of offense, 10/3/25. Okay? Now, yeah, he's got to go to a job interview. Can you just approve this as the form, or you want me just to order this on my own?
I could approve as a form.
Take a look at it. That's what I include. Any besides the general language, any dash cam / videos regarding the incident in question.
Your Honor,
Yes.
can it be unredacted? I'm defending myself.
What do you mean unredact? They're not going to redact anything.
Be that as it may, I just wanted it on the record that I'm requesting it unredacted.
But they're saying here from the Records Bureau, you November 5th, you gave me this. Oh, wait a minute, this is November 5th of 2005. All right, whatever. I'm just gonna indicate, are you representing yourself or do you want a lawyer?
I'll take a court-appointed lawyer. A good one.
Here's what I'm gonna do. I'm signing the order, Lisa. I want you to process this order in relation to this noise case. I can't possibly have them give all these files to you, sir, at this point.
What if I was?
Just please listen to me. Take back your paperwork. I have one file in front of me. If you want to get the rest of these, I'll be happy to give you orders. Lisa, can you get Heather, because I'm going to do Judge Hessen's docket for a while today. Can you ask Heather to write out all the case numbers that he's got? I'm assuming they're all out of Trenton. That's in front of Judge Hessen. She can write down what I put down as number 6 here. And then she can bring them to me and we'll get the orders entered. Is that, if she has time? And she should, because Judge Hessen's not here right now. So can you ask her to do that for me, please?
You want a discovery order filled out for all those?
Yeah, I filled out the one on the only case that's in her. I don't know the case numbers or anything like that. Just ask her to.
Yep, I'll do it right now. I'll do it.
Perfect. Thank you. Mr. Bologna, would you take this down to my judicial clerk, please?
No problem.
And then we'll take care of these, okay? Yes, sir.
Your Honor, if I may. I also wish I've been trespassed from Brulligan's Pub on 4th Street by TV Diner. There's body cam footage. Excuse me, not body cam footage. I misspoke.
Listen to me.
There's footage
Listen to
from
me.
inside the.
Listen to me.
There's footage inside the.
Please listen to me.
I didn't bring.
I didn't say you did. I don't know anyone.
Stop.
Stop. I can't just start signing orders and documents on cases I don't have before me here. You're coming in 2 weeks early. I'm trying to accommodate you, but I can't pull out all these files and start signing orders. When are those up for arraignment, Lisa? Mr. Bologna, just do me a. Go ahead.
The Judge Hessen cases are next week, and then yours are the 20th. Hers are the 13th.
This one was up on the 20th. You can talk to her on the 13th. How long ago did these incidents happen? Ago.
My concern, I have to look through my file. It happened approximately 8 to 9 days ago. The point of the matter is, Your Honor, that there's body cam footage that shows the officer swooping behind me doing a ninja move.
That might be.
And I need that body cam footage so she can see it, so I can.
You're gonna have to present that to Judge Hessen. I'm sorry.
He's a dirty cop. She's a dirty cop.
She is not. Now watch what you're saying. Watch what you're saying. That is not true. Come on. Now go down the hall, take that order over to Trenton. They'll give you a copy of it, and you're going to have to go in front of Judge Hessen. I'm sorry. I've suddenly got all these cases. I just can't deal with this right now. I'm sorry. Okay, so you're going to have to talk to her. It's not my case. Okay, I don't interfere in, she doesn't interfere in my cases, and I'm not interfering in hers.
Now, Master,
No, we're done. I got to go on. You got an interview to get to. Okay, come on. Please listen to what I'm saying. Go down and get that other order on that case. Robert Lewis Thornton Jr., 25T644-914A and 25T644-914B. And then I also have 25W837-260. Come on up here to the podium, Mr. Thornton, please. Who's your lawyer, sir?
Hi.
Okay, come on.
Your Honor, where should I go from here? Where do you want me to go from?
Why don't you go down the aisle, and I can give you the order on the case I just signed. They'll give you the order on the case I just signed. You can serve it on the police.
I can't make, are you talking to me?
The order, you can go down the hall. They'll give you a copy of the order I just signed. You can take it to the police department, but stop raising hell with those people down there. I'm telling you. Do not give those girls a hard time. I mean it, Mr. Morris. I mean what I'm telling you. Now back away from the podium. I went out of my way to accommodate you. I'm going to be fair with you, but you're not going to treat them like they're dogs. I mean it.
Okay, let's go on the record. The matter of the state of Michigan versus Stephanie Warr, 251367.
Morning, Your Honor. Your Honor, John Gold.
Good morning.
P 30758 on behalf of Ms. Warr. Ms. Warr, please put your name on the record.
Stephanie Actorling.
Okay, good morning. And so the complaint was amended last time, correct, counsel?
That is correct, Your Honor.
All right. And so there has been a resolution today, correct?
That is correct, Your Honor.
All right. Would you like to place that on the record?
Thank you. Your Honor, in return for a plea to the reduced charge of operating while intoxicated first, the people would move to dismiss the operating while intoxicated second. There's also, as part of that plea agreement, that she will attempt to get into sobriety court, in preparation for sobriety court, and of course, there'll be a PSI prepared. Mohammed puts there, but that goes with it, saying.
Correct. All right. All right. So ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay. You heard the plea that was placed on the record, correct?
Yes.
And as to the amended charge of operating while intoxicated first offense, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Okay. And you understand, ma'am, that your plea indicates you're going to be referred to treatment court?
And
Okay. You look a little bit perplexed on that.
no.
You look perplexed on my question about your perplexation. Do you understand what treatment court is? What's that?
Just perplexed.
Okay. Do you understand what treatment court is?
We talked about that.
Yes.
You don't seem confident in your yes. Would you like me to explain it to you?
Yes, please.
Okay. So a treatment court, ma'am, it's more of a specialized court within a court that allows you more intensive supervision and additional resources to help modify behaviors that continue to contribute to the offense that you're charged with.
Okay.
Okay. So, and also, it also gives you an opportunity for licensing benefits and things like that too.
Okay.
Okay.
Yeah.
All right.
Remember?
Do you have a little bit of a better understanding now?
Yes.
Okay. All right. And so knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Okay. Counsel, if you can please order your client.
Thank you. Ms. Warr, back on September 18th of 2025, you were operating a motor vehicle in the city of Southgate.
Yes.
And there come a point and you were driving south on Fort Road in the area of Vickers, which is on the Southgate side.
I'm sorry, Ford Avenue, because
Ford-
Ford Road is Dearborn and Dearborn Heights, Ford Avenue.
Fort Ave. No, Fort Street, excuse me,
Oh, Fort Street.
Fort Street.
All right, Fort Street. Fort Street, yes, not Ford Avenue. Got it.
Fort Street. And you're in the city of Southgate, correct?
Yes.
And that was in the area near Vickers, which is on the Southgate side, Fort Street, and in the area of Cedar, which is on the Lineback side of, Fort Street. Is that correct?
No, I was in Southgate.
No, I know that, but where you were in Southgate was near the intersection of Cedar and Fort Street. And Cedar and Fort Street is on the other side. It's in the Wyandotte side. That's all I'm asking. Is that correct? But you were on the Southgate side of Fort Street, correct?
4th Street and Vickers.
Right.
Nothing to do with Cedar. That's on the opposite side.
Exactly. That's what I was saying. Cedar is on the opposite side, correct? Of where you were driving.
Correct.
Okay. And there came a point in time when you came in contact with some Wyandotte police officers. Is that correct?
Yes.
And during your detainment, you spoke to the officers and indicated to them there was some problems with your insurance that you were trying to get taken care of. Is that correct?
Yes, correct.
And you took some breath tests and field sobriety tests. Is that correct?
Yes, correct.
And you took a PBT or a breathalyzer. Is that correct?
Yes.
And prior to operating that motor vehicle, you had consumed some alcoholic beverages. Is that correct?
Hours before.
Hours before, but you did consume some previous. And you were detained and you took a breath test. Is that?
Yes.
And the results of those breath tests were 0.122 and a 0.14. Is that correct?
I guess.
We'll
Yes.
stipulate to that, Your Honor. I did provide her with that information. But
Okay.
Flint's satisfied, Your Honor.
Okay. And so, ma'am, you may be wondering why your attorney is asking all these questions when it may be obvious, right? But your attorney has to make a record, which is what we have Miss Allie over here recording, so that if anybody ever needed to pull a transcript to review what happened, there's all the elements of the plea have been satisfied. Okay. So that's why your attorney has to go into such detail.
Okay.
Okay. All right. The court is satisfied the plea is known, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And then, ma'am, your next steps are you're going to go over to probation. You're going to receive a link to complete your needs assessment. You're going to also receive some paperwork for a pre-sentence investigation. You'll receive a date for your pre-sentence investigation as well as a sentencing date. You're also going to get information about the sobriety court. Okay.
Okay.
And how that goes. All right. If you were to test right now, ma'am, what is in your system?
Absolutely nothing.
Okay. All right. Bond and conditions are continued. We will see you back at sentencing.
Thank you very much, Ron.
Thank you. Have a good day. We're going to handle Ms. Brown. Let's go on the record in the matter of the City of Wyandotte versus Amy Brown, 251085.
Good morning, Your Honor. Your Honor, John Goldwalk, P 30758, on behalf of Ms. Brown. Ms. Brown, please put your name on the record.
Amy Diane Brown.
All right, good morning.
Morning.
Today is the date scheduled for sentencing on your client's plea to possession of drug paraphernalia. There is also, it appears to be 2 bond violations. One is that your client has new charges pending out of Trenton and has admitted use of methamphetamine. That's one. And that is, date is from September 12th. Your client was placed on bond July 24th. And there's an additional bond violation that your client was supposed to start testing. She left a note on October 16th that says she has a doctor appointment at 1 o'clock. It's an important visit. I will come back this afternoon and call to see what you want me to do. So she sent that at the window. And at 2:07, she sent, Ms. Shaw sent to your client drug testing information to defendant after she left, as well as a voicemail with testing instructions. And then your client, it's my understanding, did not test. She failed to register and begin testing. So we have those 2 bond violations.
Your Honor, as to bond violation regarding the allegations of picking up a new matter, it's my understanding that they are detecting those matters in the 33rd District Court. That the next court date there is, November 13th of 2025. As to the allegations, it is my understanding, I just received the reports for the police report, and as I've indicated, she has counsel been appointed in that particular matter, and the next hearing on that particular case is the 13th of November. There are allegations, but as the court is well aware, there are only allegations. As to the bond violation with respect to the testing, she would plead guilty to that. Is that correct?
Yes, that's correct.
If the court wishes to, and then we can address sentencing, unless the court wishes to adjourn sentencing until we have a better handle on what is occurring in the Trenton 33rd District Court. But we have reviewed the plea side, prepared to address that. And I didn't know, at least on the Seward Court has commented that as part of the bond violation, the second one, that there was admitted use of meth, and she is vehemently denied that.
Well, that's the first violation, but
Oh, that's
I'm also,
I
trying to
thought
see where that admission, was that admission to your probation officer, or was that admission to, in the police report?
That was to the probation officer at the time of my assessment.
And so on bond violation number 1, you want to set that for a hearing, or you want to adjourn it until after the 13th.
I would, if we're going to set over the sentencing as well, I would think we should.
Well, I don't know if I'm going to adjourn the sentencing. I'm not sure yet. So let's handle bond violation number 2 as far as the drug testing.
Well, I'm sorry, I haven't back. I thought the drug testing,
That's bond violation 2. The first one about the police contact and the charge that your client has pending in Trenton is bond violation number 1, because that occurred September 12th.
oh, I'm sorry, Your Honor. I thought that the failing to test was,
Bond violation number 2.
okay, well, then she would plead guilty to, as I've indicated. I got confused when you started talking about the meth.
Please raise your right hand, ma'am. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You heard the plea that was placed on the record as to the bond violation, correct?
Correct.
As to the allegation that you did not register for testing nor test How do you plead?
I plead guilty to that.
You've gone over you understand that you do have the right to have a contested hearing in this matter. By entering into a plea, you will not have that contested hearing.
I understand that.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
I'm sorry?
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, counsel, if you can please voir dire your client on bond violation number 2, which is the testing.
I'm sorry, Ms. Brown, you were placed on, provisions for bond, pending. Is that correct? And one of those conditions was that you were to test, for alcohol, drugs, etc. And you were to register for that. Is that correct?
Yes.
Did you register for that?
My understanding was when I went to go register,
It's yes or no. Did you register or not?
I don't know. No, I guess not.
Well, did you go down here, fill out the appropriate paperwork, and then notify your probation officer or the testing facilities that you were to appear for testing?
No, I just received paperwork from my probation. That's all I received. So no.
Well, did you come down here and talk to them and leave a note that I have to leave?
Yes, I did.
And then you received information, but did you follow up on that information?
I tried to. Unfortunately, I work in Ann Arbor, so my time, I could not make it in the amount of time that they allow for testing. However, I did send an email to the testing place to see if there was somewhere else I could test so that I could follow through with the testing. I called the first 2 weeks and my color had not gotten a call. And then my timing was misunderstood. I thought it was 7 a.m. to 9 p.m. and it was 7 a.m. to 9 a.m. and then they have evening hours. I work in the morning from 9 to 7 in Ann Arbor. So I don't know if there's some way that I could work out getting to testing so that I could get there.
Yes, it's called before work. It opens at 6 a.m. or 6:30 or something. I don't know.
Okay.
So, all right. The court satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea of guilty for bond violation number 2. So, ma'am, did you contact the court here at any point?
I did. I contacted Natalie Shaw,
When?
and I let her know that I was going to get into.
When?
I sent her an email when the first time that my color had showed up, which was about 2 weeks ago.
Okay. When did you finally register and start testing?
I have not yet.
Well, then hold on. Did you register for testing?
I didn't know I had to register for testing. I thought I just
Then
had,
how do you know if your color has been called?
because she emailed me paperwork that told me what my color was and where to go test. So I thought that meant I was supposed to call every morning like I was doing, and when my color was called, I was supposed to go test, which I tried to do. I know they were closed, so.
All right, let me take a break in just a moment and figure this out because I'm more confused the longer we're going on. So let me I'll just have you sit down for just a couple moments and we'll recall this matter, okay?
Thank you.
So on the record, in the matter of the state of Michigan versus John Pruitt II.
One girl on my plate, be 35-143 on behalf of Mr. Pruitt. Thanks to my right.
Good morning, and sir, your name for the record, please.
John Pruitt II.
All right, thank you. Change the date scheduled for the adjourned pretrial in this matter. And counsel?
Your Honor, at this time, my client is going to enter a plea of guilty under threats of command political.
All right. Sir, please raise your right hand. You solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay. You heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the charge of domestic violence, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand that by entering into a plea, you'll be waiving some of those rights.
Yes.
Do you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
You also understand what the 769.4A status is,
Yes, Your Honor.
and that if you're eligible, the court would likely assign that eligibility to you. Do you understand that?
Yes.
You also understand, sir, the recommendation is probation, alcohol assessment and treatment, anger management, no contact, and any additional conditions set by the court. Do you understand that?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Counsel, if you could, I'm sorry, any immigration issues?
No.
Counsel, if you can please border your client.
Mr. Pruitt, was it October the 12th, Your Honor? On the 14th. 12th or 14th?
12th.
Okay, the sitting of Riverview. You were there, correct?
Yes.
And you were at your home with your wife at that time, correct?
Yeah.
There was an argument between the two of you,
Yes.
and she indicated to you that she wanted a divorce,
Yes.
and you took off your wedding ring and threw it towards the dresser, and she was near the dresser, correct?
That's correct.
Oh. Satisfactory. That's the allegation. That the ring was, the throwing of the ring was an assault.
Okay, well, how close was your wife to the dresser?
It's like a 6-foot long dresser. To be honest, I was packing a bag going to my dad's house, and I just took it off. I was just like, "Here, you can have it." And I just threw it at the dresser.
She says he threw it at her.
Well, counsel, I'm not hearing a factual basis to accept the plea. So,
Yeah, it's,
I mean,
like I said, I can't make him.
no, I understand that. I don't have a factual basis. And if you want to have the prosecutor come in to see if he wants to voir dire your client.
They felt that the fact that he threw it in the area where she was, that was an assault.
Well, an area, I need to know like the proximity of that area. So,
Near the dresser, correct?
Yeah, I would say within 2
And she had one of your children in her hands, correct?
Yeah, she was holding her 3-year-old daughter.
All right, and you threw it and it got within what, a foot of her or so?
Yeah, my back was turned because I was packing a bag to go to my dad's.
Did it bounce off and hit her? Isn't that what she said? Or-
That's, I believe, what she said.
can we get the prosecutor? Gordy, can you have the prosecutor come in, please?
I think the complaint is in the hallway. Two judges.
Okay.
Oh, that's-
All right. And good morning, Mr. Mohammed. Your appearance for the record, please.
Good morning. I'm on behalf of the people.
All right, thank you. And so, on Mr. Pruitt, we're at the voir dire stage, and based upon the voir dire that's occurred so far, the court has not heard a factual basis by which to accept the plea. So would the people like to voir dire Mr. Pruitt as to the factual basis? What the court has heard is that there is a ring tossed at the dresser, and Miss Pruitt was in the area of the dresser. And then the court also heard that Mr. Pruitt's back was turned and he just threw it at the dresser. So I don't know what all of your discussions were. I don't know the information you know. So would that be accurate, counsel, as far as what the voir dire has been so far?
Yeah, basically, that there was an argument and that she requested a divorce. He threw his ring in that area where she was near the dresser.
Okay, I can go from there.
Thank you.
And so, sir, would you say that a reasonable person would feel in fear of that? I understand it may have not struck her, but would a reasonable person have been put in fear from the manner that was displayed with throwing of the ring?
Yeah, I could understand that.
Okay. The court will accept the plea as knowing, voluntary, and factually accurate. The court will accept your plea. And the court will order bond and conditions are continued. You're going to get your next steps, sir, over at probation. And you will receive your information regarding your pre-sentence interview, your pre-sentence interview date, as well as your sentencing date. Let me also just ask a question. So I know this question is for counsel, whether it's Mr. Hyder or Mr. Muhammad. Has the phone been turned back on? Because the court had originally ordered a GPS tether for Mr. Pruitt, and Mr. Pruitt was unable to comply with that court order because the phone had been turned off by Ms. Pruitt. That was what was stated on the record on October 23rd, correct?
That's correct, Your Honor, and I believe Ms. Pruitt is in the courtroom. My client, Mr. Pruitt, has tried many times he's contacted the phone company, and because she exercises control over the account, she won't authorize turning on the phone. So, and then again, Your Honor, as I indicated, I know you don't have jurisdiction over her. It's been 3 weeks. He still hasn't seen his children. Counsel represented to me that she said he hasn't attempted to contact her
She's not allowed to contact.
No, but he has been allowed to, through a third party, contact and request, which he's done numerous occasions, and she refuses. And I've been told that she's afraid that he won't give the kids back, and that's just not true. He just wants to see his children, and I know you don't have jurisdiction over it, but I wanted to make that record, because that's what's been reported to me.
Okay,
Judge,
thank
if I
you.
may respond.
Yes.
So I did have an opportunity to speak with the complaining witness, and she's indicated to me that the defendant has had contact with her. However, it was not in regards to actually wanting to see the kids. Not just that, since the last hearing, there's been some developments, which is actually why I would like to renew my motion. At the previous hearing, I requested for the court to impose an alcohol tether on the defendant because I believe he posed a danger based off of his previous conviction and what's been relayed to me by the complaining witness. Since then, I've been informed that the defendant had gone to the school where the complaining witness was with her child. He was
Unbeknownst to him.
Well, hold on. Let Mr. Muhammad finish, please.
He was intoxicated. He drove there, and there was contact between the defendant.
Stop interrupting, please.
I was informed that he drove there. How he got there, I guess that's a question for an investigation to be done. But that's what I was informed of, or that's what's being assumed. But he was intoxicated, is what I was told, and at that time, there may or may have not been an assault that occurred between another individual, not the complaining witness in this case. And there was contact made between the defendant and the complaining witness. So that's what I've been informed.
What was the contact that's alleged, counsel?
Your Honor, here's the way I understand.
Well, Mr. Haidar, hold on, please. Just a moment.
Judge, I think I was informed there's multiple things that were said. I think it's best for the complaining witness to present that to the court under oath. I don't think it's appropriate for me because I don't want to speculate on what's being said or secondhand knowledge. I have no objection to her informing the court what was said, but what I was told was that he did go to that location at the school. He did have contact with her. He was intoxicated. At least it appeared he was intoxicated. So based on that, I'm not requesting for the court to impose any jail, but I do think that, and I'm going to renew my motion for an alcohol tether because I do think it's appropriate for this specific person considering the circumstances of the case.
Well, I will conduct voir dire of the complaining witness. However, I will also entertain the tether issue. But if your client, if the complaining witness isn't turning the phone back on, then I can't put a tether on. That's as simple as it goes. There needs to be a phone for both alcohol and GPS tether. And I can't do that since she's turned off the phone and she won't turn it back on. So I'm going to voir dire your client, counsel. You can voir dire your client as to the allegations of contact. But at the end of the day, your client, the complaining witness is going to have to turn on the phone for Mr. Hyder's client.
I understand, and Judge, I have no knowledge about the phone, so.
Okay.
As much as I am.
All right. So counsel, I'm going to have you and your client step over to the side for just a moment. Good morning. Please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right. And if you can please state and spell your first and last names for the record, please.
It's Gage Pruitt. Geubitt.
Okay. Thank you. Okay. And Mr. Mohammed, did you want to voir dire the complaining witness?
I can, yes.
Okay.
Ma'am, I'm going to take you back to the day of October 24th, 2025. Did something happen at or near the location of 17510 Bellade Avenue in the city of Riverview, County of Wayne?
Yes.
And what transpired?
Yeah. So I had to pick my daughter up from preschool. During certain times of the month or every other month, you have to volunteer to clean the school. So the school sends out reminders on Facebook for the parent that's responsible for being in that day. And I've obviously been by myself, so my mom was with me, and I asked her if she could get Violet while I do my cleaning duties at the school. So my mom's there. I'm there about 15, 20 minutes early, and I'm in the bathroom and I'm cleaning, and I start hearing my mom and the teacher yelling, and I could hear Randy screaming, where's Violet? Where's Violet? And so I come out of the bathroom, which is in the back of the school, and I see him tugging on my mom and take Violet and start running out the door. So I go around and go outside of the school, and obviously like my mom and the teacher are trying to come with me because he's clearly intoxicated at this point, fumbling all over himself.
Wait, I'm sorry. How do you say clearly intoxicated?
Another mom had said that he fell out of the car in the street walking up to the school already. And then when I was watching him, I mean, he was visibly intoxicated, meaning like his motor functions were not working properly. So I told my mom and teacher, I just looked at him and I said, call the police. Let me just talk to him. Because at this point he has my daughter and he's taking off down where there's a playscape down there. So he's taking off down to the playscape. And so I'm just trying to talk him through, like, Randy, you just need to stop. The police are coming. You need to give me back Violet. You need to stop doing this. And it was, the cops are coming here to investigate you. You're going to be in a lot of trouble for this. Why are you doing this to me? I still love you. Do you still love me? And at that point, the cops had came and got Randy and took him to the side, and I was able to get my daughter and go off the other side.
Okay. Tell me about the phone. Did you turn off his phone?
I did. Yes.
And why aren't you turning it back on?
Right now there's a business that's connected to my phone line. That's his phone number. I've had a lot of people within the business reaching out to me that their cars are stolen, that Randy's refusing to give them their cars back. I don't want anything of mine associated with this business. I don't want to have to deal with these people asking me where are their cars, that I have all of their car keys when I don't have anything except for my one car. That's it. So for me, I want absolutely nothing to do with the phone line, with the business. I don't want it associated to that account on Turo.
Okay, so then why didn't you just transfer it into his name instead of completely turn it off?
Like the account's under my name.
Right. So why didn't you just transfer it over to an account in his name?
But he could, I guess I'm not understanding. Like he could open up his own account. I just don't want the phone number associated to me.
Okay. So Mr. Hyder, your client can take the phone number and open up his own account.
Well, go ahead.
Okay. I have tried on 4 occasions. I have 2 emails on my phone right now to do a port transfer. She has declined every one of them.
Ma'am?
The emails.
Yes.
Well, why are you declining? If you don't want it associated with you, why don't you just allow the port transfer? I don't understand. Why would you decline that? Twice.
I just don't want the number associated. I wanted it completely shut down, and that's
So then why did you decline it? Why did you decline the port transfer? That would have transferred everything over to him and disassociated it from you. Why did you decline the port transfer?
I just didn't want the phone number to be active anymore.
But you also want a tether for protection.
I do.
You can't have both. You can't have both.
I agree.
So you just didn't want the number to be active,
Correct.
okay? To affect his business?
For me not to be associated with the business.
I understand that. If the port is transferred to him, it won't be associated with you.
I'll turn it back on.
Yes, 100%. That has to be occur by 3:00 today so that Mr. Pruitt can have the alcohol tether fixed. That's what we're doing.
Okay.
Mr. Pruitt, thank you very much for coming in, ma'am. So by 3:00, ma'am, you need to well, let me do this. Let me state this. There's no contact between the two of you. So however you were going about asking for the port transfer previously, do it again. And she's going to accept the port transfer. So long as it's no longer associated with her, which I presume on a port transfer means it's taking the entire account, the number and all, transferring it over to you, and it will be disassociated with Miss Pruitt.
Yes.
Correct? Okay. Ma'am, you are not allowed to decline that. All right. Now, in the event there's some large amount of money that would be associated with doing that would be attributed to you, then I don't know how that gets resolved, but that will be between counsel. I don't know. What I do know is that the phone needs to be activated so that Mr. Pruitt can go and get that alcohol tether on today. All right. Now, Mr. Pruitt, let me be very, very clear. While I don't have jurisdiction over the parenting time and the custody of Violet, counsel, I can understand why apparently there's some concerns by Miss Pruitt that your client's going to not return Violet because he went to the school and took her away from the school, was attempting to take her away from the school. So all I'm saying is this, Mr. Pruitt, right now, the child is with Miss Pruitt. Okay. Based upon the restrictions that this court has on from the allegations that occurred that night, I'm not making a determination about parenting time or custody. If you want that determination to be made, you need to file an action in the Third Circuit Court. Until then, the situation is what it is. I cannot order any parenting time, arrangements, times, or otherwise between the two of you with Violet. If there was a pending order, I could address that. There's not. So until such time as there's a pending order, or until such time as the two of you have some type of understanding regarding Violet through a third party, there isn't any parenting time for you.
Right. Just so you indicated at the hearing that a third party could contact her regarding parenting time only, and he's attempted to do that. And I guess, what you're telling him is absolutely true. You can force it. She refused to let him see the children. On this particular day, he wasn't aware that she was there at the preschool. He is very involved in that preschool himself. He would oftentimes be the one to pick up his daughter and do the cleaning. So it wasn't like he was trying to see.
And counsel, I can appreciate that. That's why I'm not indicating there's a violation of bond conditions regarding contact. Potentially, there could be an issue regarding consumption of alcohol, which this court ordered you not to have. But we also don't have any type of testing or anything like that. So let me be very, very, very clear, sir. You are going to get that alcohol tether on this afternoon. You are also going to be tested before you get that alcohol tether on. Will there be anything that comes up in your system when you're tested? When's the last time you consumed alcohol?
It's been a while. I just tested at DNA yesterday.
Okay, so counsel, I'm asking this question not because I'm going to then initiate a bond violation against your client. Full transparency, sir. When is the last time you consumed alcohol?
After that day.
No, not after that day, no.
Okay. But you will acknowledge that day was while you were on bond.
Yes, yeah.
And you're not allowed to consume alcohol.
Yes, Your Honor.
Do you know what that means?
Do not consume.
Yeah, you disregarded the court order and consumed. So that is why I'm ordering you to have an alcohol tether, right?
Yes.
I know that that was also raised previously. And the reason why you don't have it is because you don't have there's not a way that that can occur because you don't have your cell phone. That's all going to be rectified today. So then you will have that alcohol tether on today.
Your Honor, I did speak with Mr. Muhammad, and he told me he was gonna bring up the issue. I really didn't have an objection based on what we know, but he also indicated he didn't feel, and I don't feel, that the GPS would be necessary as well.
No, it's only the alcohol tether.
Okay.
The court removed the GPS tether portion of it last time based upon the lack of a telephone service. But in this regard, the court's going to technically amend its prior order from, I've already terminated the GPS tether, so I'm adding the alcohol tether.
Thank you.
Okay, and so that court request, sir, you're going to leave here after you go to probation. So presumably you could be there by 1 o'clock, correct?
Well, she would have to have the.
You'd be able to be to the phone store by 1 o'clock.
Yeah, should be. Yeah.
Okay, then you can do the port transfer. So then, ma'am, you will have to accept the port transfer, which will then allow you to be over to the facility for the alcohol tether not later than 4 p.m. There's plenty of time for all that to occur, including traffic and travel time.
Right, it's just the preconditions for removing her objection, right?
She doesn't have an objection anymore.
No, well, I know she doesn't, but if she waits till 2 o'clock.
I think that Ms. Pruitt's
I hope so.
more focused on your client maintaining sobriety than she is waiting until the last minute to accept the transfer for the port. So that will not be an issue. Because if it is an issue, she could quite frankly be back before the court on a show cause. So,
absolutely.
Your Honor, can I ask one thing?
What is that?
Would it be possible to do the tether tomorrow morning just because I have a ton of work that I have to catch up on?
So I can appreciate that, but no. Ma'am, the moment the port request is sent to you, accept it. Okay? Okay, thank you. All right, bond and the balance of conditions are continued. And I certainly hope, sir, that you're not going to put your child in that position again, trying to go to the school and take her home. Okay? Not unless there's a Third Circuit Court order that would say otherwise. All right, thank you. Have a good day. All right, let's go on the record in the matter of the state of Michigan versus Dennis Holbrook, 25916.
Good morning, Your Honor. Mohammed on behalf of the Your Honor, Alex Linden will bring on behalf of the defendant, whom stands to my right.
Thank you. And sir, your name for the record, please.
Dennis Hill.
Okay, thank you. Today is the date scheduled for the exam, preliminary exam in this matter. We had set quite a bit of time aside so that the exam could occur. We did have an in-chambers conference previously this morning as to the ability of each attorney to proceed or not to proceed. So, counsel, those are the transcripts?
Yeah, I'm sorry, it's the transcript and my other exhibits, and they stack about 6 or 7 inches tall. I brought a copy for the court, brought a counsel.
Okay, thank you. Okay, and a counsel appearance, or I'm sorry, Mr. Mohammed?
Yes, Your Honor. In regards to the documents that were provided by defense counsel, I think it ranges anywhere from 500 to 700 pages. And I received this on Monday. I reached out to defense counsel and I requested, to see whether or not they would stipulate to an adjournment of this hearing due to the large amount of documents. We'll need an opportunity to review and go through all of that. It's my understanding that the circuit court had amended or modified their custody arrangements where they gave the defendant full custody.
So my client's the plaintiff in the custody, excuse me for interrupting, but my client's the plaintiff in the custody case and they switched custody to my client.
Correct. They had, my understanding is off of the representation is full custody is now with the defendant of this case. And based on that information, I think we must go through this, and by we, I mean my office. It could potentially change the outcome of how we move forward with this case. And I'd like to just renew my motion to give us an opportunity to go through all of this, all these documents that we have before us in order to make an informed decision on whether or not we should move forward.
Okay.
So at this time, I'm going to request for a 2-week adjournment.
Okay,
Your Honor, just so the record's clear, we were in chambers, we went into detail as to my journey to get these transcripts. I didn't get them till last Sunday, even though I've hand delivered requests to the transcript department of the Wayne County Circuit Court. Having said that, we're here for the preliminary examination. I'm going to ask for dismissal.
And Judge, if I may, just to add on, Monday through Thursday, I am in court. So that goes into why we were not able to go through this. However, I did reach out to the officer in charge, he's here, Detective Sabo. I asked him to go through as much as he can. He's reviewed it and he's informed me that he agrees with the idea that an attorney does need to review this, and we do need an adjournment in order to move forward, because this does need the eyes of our office to thoroughly go through. And as the court can see, it's very large amount of documents, so we are requesting for an adjournment.
I do want to make one comment, Judge. I was reviewing the preliminary report in Wayne County Circuit Court on August 14, 2025. The court did make mention that my client committed no violation of any order. And that dovetails into the fact that I have a pending motion to dismiss based on crossover estoppel. So I think that is important for other counsel to be able to review that. But we're here today and I'm asking for the dismissal.
all right. The court will note that, yes, it did speak with both counsel in chambers, and the court did receive detailed information from Mr. Lazube as to the procedure and the dates as to when he requested the transcripts. The court will note that it did set this matter out 6 weeks in the event to account for the time that it would take to obtain the voluminous amount of transcripts. Mr. Lazube did not utilize the mail. In fact, he went and hand delivered the check, and he was actually informed of the wrong name of the court recorder or the court reporter that would be responsible for producing the transcripts, and he had to so there was some slight delay, but it was not on the part of counsel. And the court will note that counsel did a number of follow-ups as well with the court recorder or the court reporter on when he needed those transcripts. The court will also note that Mr. Mohammed, that does take judicial notice. Mr. Mohammed is in courts Monday through Thursday and would not have necessarily had an opportunity to review the voluminous amount of transcripts to prepare for today's exam. The court also understands that in review of the transcripts that there would also no doubt be further evaluation that would need to occur in this matter as a result of the review of those transcripts. The court will also state that this matter has been pending. Arraignment was August 7th of 2025. We are on November 6th. So we are 3 months in. And based upon a multitude of calendar factors and holidays that occur and availability of witnesses and attorneys, we cannot proceed in 2 weeks. The court also doesn't find that it is in the best interest of justice to have Mr. Holbrook having this matter hanging over his head for another 2 months at the earliest before the prosecuting attorney's office can determine whether or not they're going to proceed or not proceed. So it is this court's in this court's discretion, it is in the best interest of justice to at this point dismiss this matter without prejudice. So that means the prosecuting attorney certainly has the authority to reissue the charges if after further evaluation of the documents that they have received, that is their intent. So the court is going to deny the request to adjourn. The court's going to grant the motion to dismiss, which would also resolve your motion at this time as well, Mr. Lazube, regarding the prior motion you had filed.
Thank you, Your Honor.
All right.
Thank you.
And there was a personal bond, so there isn't any of that that needs to be addressed. Okay?
Thank you, Your Honor.
All right, thank you. All right, have a good day. Let's go off the record.
We will go on the record in the matters 25 CF 43, 25 CF 42, State of Wisconsin versus Kenneth Actorling, and State of Wisconsin versus Stephanie Actorling. Appearances are, we do have the state appearing through District Attorney Kevin Schmidt in person. We do have Kenneth Actorling appearing in person with his counsel, Michelle Erdman. We have Stephanie Actorling appearing in person with her counsel, Charlene Perrin. We're set today in this matter for the final pre-trial. This is the court's drop dead date. We do have a speedy trial currently set for 5 days to begin on December 1st, 2025. There are certain things that we do have to handle and take care of here today. As this is the final pre-trial, I'm pulling up the court's scheduling order in this matter so that we can make sure that we go through everything, because it needed to be, everything needed to be done according to the deadlines provided by the court in the scheduling order. I'm going to start with Ms. Perrin. Can you please provide me an update on whether or not you believe that this matter has reached an agreement or is close to reaching an agreement, and you just need a few little moments or other moments to tweak it?
At this point, there is no agreement.
All righty. So anything else that you can update me with regards to your case? Because according to the scheduling order, we do have certain dates that we have to abide by. Because again, this is a speedy trial and we need to make sure that we are ready to go.
So I filed our motion limiting, I believe, I filed a letter about our expert, but then
I've reviewed that with the DNA expert. Now you're pulling that back. I reviewed your motion in limine. I didn't, in your motion, didn't see anything too different.
Nope.
Okay.
Nope, there really isn't. So, no, Your Honor, there's nothing at this point that I think I really need to raise with the board.
Excellent. Thank you, Ms. Perrin. Ms. Erdman, I'm going with you second because you did file your motion in limine as well as your motion objecting to a lay testimony by I don't even know what kind of the MOCIC, I don't know what that stands for, but that MOCIC employee. And so I have reviewed all of them, and this is the date and time to discuss these matters so that we are all prepared to move to trial. Because again, this is my drop dead date. That means the court will not accept any agreement after this date. That means that if we move forward, either the defendants must plead guilty to all of the counts that are charged against them, or the state must dismiss those counts or some of those counts outright. Otherwise, the matters will proceed forward to a jury at that time, if convicted or for the trial, and then we will proceed later. So Ms. Erdman, this is your time to make any arguments as to your motion.
Judge, I filed both a motion in limine and then a separate motion addressing, I guess, what could be kind of framed up as lay testimony in introducing cell phone site data. I think that's probably the bulk of what would be addressed, so I'll start there. And essentially, I think there's a couple of concerns. So the way that this case came on was a speedy trial demand that I don't know that anyone, myself included, was expecting. So we've all been working hard to comply with the deadlines. We had a conference and the court gave us a scheduling order And in that order, I noted that there was particularly something referenced about making sure that Daubert hearings were heard timely. I kind of gave it some time waiting for the state's witness list, anticipating that I wanted to file one, but didn't see the state's witness list forthcoming. At that point, I just wanted to put everyone on notice, hey, I want to make sure that everyone knows this is an issue. And I think the Daubert issue really came down to whether or not the correct person would be seeking to submit the information relative to cell phone, and kind of based on a lot of the technicalities that are involved, things like whether or not the whether or not the cell phone sites, are on a hill, and how that can impact the reception, and the location isn't exact. And there's this concept where a pie chart is typically drawn, which is kind of like a 90-degree angle, and how that really isn't necessarily meant to be interpreted literally, kind of thing. And so I put that Daubert motion out. The state rightfully pointed out I had an error in my motion that had listed some recycled a motion, so the names listed were nonsensical. They weren't applicable here, and I acknowledge that. That was my mistake, and it was just a sloppy mess. And so the motion was out there. The state then responded by email. I don't intend to use a expert. I expect that this will come in under lay testimony and cited a case. And so it was only, I think, 2 days ago or yesterday, I can't remember when I was working on it, that I was able to really sit down and digest the issue. So I apologize for the tardiness. But essentially where I've landed, Your Honor, is that it's an unsettled standard in the state of Wisconsin, whether or not expert testimony is required when introducing cell site data. And the case that was cited by the state is U.S. versus, or state versus Cameron. That's 2016 WIS App 54. And that essentially adopted an unpublished opinion, state versus Butler, 2014 App, AP 1769. State versus Cameron was a case fact pattern where there was a stipulation as to the accuracy of the cell site information. So the data from the cell phone provider was already stipulated to, and it was literally a plotting exercise on a map of taking the latitude and longitude coordinates and applying them to a piece of paper. And in that case, the courts held that it doesn't really require any kind of specialized knowledge, and that it doesn't take an expert to make a map using cell phone tower data provided by the phone company. That was the holding in that case that the state was purporting to rely upon. And so as I've set forth in my motion, there's a couple of things. One, this is not stipulated to information. And two, the attachment that the exhibits that I attached, exhibit 1 is a copy from the provider, it's AT&T in this instance. And there's a couple of cautionary disclaimers at the top. The results provided are their best estimate of the location. Please exercise caution in using these records for investigative purposes. Location data is sourced from various databases, may cause location results to be less than exact, right? So that was kind of the place where we started. And then at the bottom, it's disclaims that it's proprietary information. That's so it's using a compilation technology that they're not willing to disclose to the outside public world. And so, Your Honor, we'll see on exhibit 2 is the data that was put together by the analyst from, or I guess I'm not sure of her position there, but the MOIC person out of, I think it's Missouri is where the lab is located. And I just want to, I guess, call to attention the purported caption or heading of this: all cell sites for calls, data, SMS messages, and time in advance for this phone number for this time period. That's what the exhibit is purporting to show. And then there's a pin where the quote unquote burglaries occurred. So that's noted in the top corner. And so then if you scroll down, there's a second pin that's been added, and that's the area frequented by subject. And if you kind of look between the two, right, if you start at the top and then look to the bottom, the area frequented by subject is not supported. It's not supported by the cell site data. So that seems to be kind of a hearsay, or that information likely came from an alternate source. And then as it goes forward, they've applied the familiar pie shape kind of notations, etc. And it goes into even, broader strokes that way. So what the state, I believe, is saying now in the response that I saw is, well, I can still do this, right? I'm going to just use the AT&T witnesses that weren't disclosed yet, because I reviewed the second witness list filing that was made within the last week or so. There's still no one listed from AT&T to introduce business records, such as the cell phone location data. But the state's saying, I can get around this, and my expectation is I would just call these folks, have them say, this is our business data, this is the detail, and then we've simply just done a mapping exercise. That's how the state's asking to introduce this. The business record obviously will be subject to cross-examination, especially as it relates to the disclaimer at the top. But I think I would pose to the court, even if we've got someone sitting here from AT&T who says that we at AT&T pull latitude and longitude data using some various sources that we consider proprietary, but they're databases, and we use that to compile this. And then the state is permitted to take on that mapping exercise. At what point in this process do we hear from someone who can say, but wait, this is something that's next level, this compiling of data at the source involves certain levels of expertise, certain levels of software. Here's how it works, here's how it's explained. And this is why what you're seeing on the map looks the way it is. And I'm sure the state will be very quick to say, but judge, if the defense wants that kind of information to come before the court, then it's the defense's burden to provide that technical detail. I simply want the ability to take what has been deemed less than exact, that's the words that they use, less than exact data from AT&T. I just want to take it and put it on the map, judge. And if the state doesn't like, or if the defense doesn't like it, then they should bring in someone to tell me why I can't. And I think that it's something that the court really should be aware. The federal courts have held a variety of different ways on this. It's not settled law in Wisconsin. I did give you the cites in my motion that there were some people that were pretty vocal that this needs to be introduced at an expert level. That's at the federal level. But I will also say, in certain instances, under the correct amount of correct circumstances, where there's already either a stipulation as to the accuracy of the data, or at the lowest level, there's just not a lot of contention, that the courts have been open to allowing people to do kind of, I guess, what amounts to a mapping exercise, right? Take and plot, location A here, location B there. But I guess the confidence of the data to begin with this less than exact disclaimer, and then taking it and applying it as they have on Exhibit 2 and saying this represents all data, all sites, all cell sites for the calls, right? And P.S., sometimes calls bounce off of one tower to a second tower to a third tower simply because of the way, Your Honor lives in the Northwest. You understand cell phones are not, precise and exact. They don't necessarily always work in certain areas. There's some areas that are better than others. It has to do with topography, etc. So I think it's something that we just, I guess, need the court to be mindful of what's been done in the past. Our urging would be that the court say that this, based on this level of detail, without someone coming in to interpret, it's just not sufficient to be introduced in this manner.
Thank you. Ms. Perrin, I know this is not your argument, but you are a co-defendant, or you represent a co-defendant in this case, and so your opinion on this matter, your statement as it relates to your client is important.
Right, I would join Attorney Erdman in her argument, and I can file a motion as well.
You don't need to file a motion as well. I think I will take this as an oral motion to concur and side with the arguments made by Ms. Erdman.
Yes, and she did tell me about it, and we did talk about it the other day. I haven't had time to file anything, but I did review the federal and the state cases. I agree the federal cases do support not allowing the state's witness to testify about this, and I agree that this Wisconsin state law is not settled in this area.
All right, thank you. Mr. Schmidt.
I have two main thoughts on this topic. One, I don't know how the court could accept the arguments by the defendants without just completely eviscerating everything Cameron stands for. When I look at paragraphs 25 and 26 in Cameron, they specifically address this exact argument. This was the argument put forth to the Cameron court. They talked about what the experts said about accuracy and reliance and mapping. And in paragraph 26, the Cameron court says all that stuff, it goes towards the weight of the evidence of the cell phone location mapping, not to the admissibility. So I think what the court is hearing right here is not an argument that this evidence is inadmissible for some reason, because they are admitting it's layperson testimony. They are not saying this is Daubert. Then this argument is an argument for a jury. It should be, hey jury, the top of this document that Manny Britton used says it's inaccurate somehow. What does that mean? State didn't present that. The weight of this evidence is lesser. This doesn't bear towards credibility. And in fact, Cameron cites positively towards courts accepting cell phones in 2016 without a Daubert hearing or mapping data on it. It's 9 years later. There isn't a single person in this courtroom who doesn't have a cell phone. There isn't a single person anymore who doesn't know how cell phones track location through cell towers to satellites. This is not something that is needed for expert testimony anymore. I think you'd have a better argument saying that juries would need expert testimony to understand a landline more than they'd need to understand a cell phone, just because of how times have changed and the ubiquity of cell phones in human life, and specifically with like the location data. Who has never used Google Maps or something like that? When a person alleges that something requires an expert, what they're actually alleging is that it is something that requires expert testimony. That is, the jury needs an expert to interpret or understand what it is, how it was collected, why it exists, or anything like that. This isn't that kind of data anymore. People understand that the GPS collects your location data. If the defendant brought like an expert or something to testify to that, it would just be an attack of the credibility of evidence. It wouldn't be like, this shouldn't come in because I found an expert who says this is inaccurate and people shouldn't rely on it. And that goes again towards, we should be talking about admissibility, not weight of evidence. Second, and this goes towards like a broader complaint I had about all the motions in limine filed by Mr. Actorling, is they're filed yesterday. I had minutes to hours to respond to any of these. I'm not forfeiting that I think Cameron is abrogated or overruled or language in it is dicta because of federal cases. I think that the cell phone data comes in as a certified business record. Mandy Britton can map it based on Cameron. And if they want to attack the weight of evidence because there's no one from AT&T to explain how it's collected, that's up to them. What I wrote in there about all of these issues being solvable if I lost a hearing on any of these related to the timeliness of the motion. The defendants, I don't think it's reasonable to play dumb and say, I don't know who they're going to call until they file a witness list. They've had this information for months and months and months. It's referenced in the criminal complaint. It's unreasonable to think I'm just not going to use evidence I've given them or I've referenced in the criminal complaint. And the reality is I'm kind of being thrust into 1-day notice motion hearing right now. And if the court rules against me in normal course, what I do is, well, the solution is I just call someone from AT&T and then I still get it in. But the problem with, requesting a speedy trial and then doing the motion eliminate the day before the end of the deadline per the scheduling order is I'm kind of just prejudiced and a victim of brinksmanship, really. Like, a speedy trial is not intended to force a shotgun wedding where everyone has to go to a trial where people are unprepared or who've taken reasonable deliberate actions, which I think the state has done in this case. And the way they know State v. Cameron is I notified them and said, I don't think this is expert testimony. I let them know that in case they did want to challenge it in a timely fashion. So I think the court should find it does come in through State v. Cameron. And yeah, and if we're just addressing this, then I assume we'll move on to the other things. Thank you.
All right, thank you. Brief reply or rebuttal?
Just, I guess, I do acknowledge that a day for attorney Schmidt to prepare is unfair. Like, I'm not trying to push things. If he needs some time to review, but I still maintain that the court making, even if I was ineffective in bringing this at the last minute, it's certainly something that warrants review.
Well, I appreciate that. Thank you. And Ms. Erdman, I do not, even though there could be an argument against that, and there is an argument from the state that with regards to timeliness and the scheduling order, et cetera, it's well-versed in case law that courts must be a little bit more lax when it comes to scheduling orders in criminal matters versus civil matters. In civil matters, I can be cutthroat. Nope, you did not follow that to the letter. So absolutely no, even case dismissed, whatnot. But this is a criminal matter, and I have to look more and to put more weight on the defendants and their constitutional rights and the need to be heard. And that's exactly why we are having the hearing today. And I do understand that it puts the state in a little bit of a tight spot to have to argue it here today. But I'm going to tell you, state filed a motion, and as you can see, I review and I read things. And the state was able to make a pretty thorough argument in a brief amount of time. I think after receiving your motions, it was filed within an hour after that or something, bing, bang, boom. So I think the state has had the ability to be prepared. And so this is adequately in front of the court here today. If by chance either side would like to have an argument after the fact, even though this is a final pretrial, the drop dead date, the court will still allow that in writing. However, the court is more lax as it relates to the deadlines in the scheduling order in a criminal case. And that's where I am, and that's where I'm going to be. So even though it is past the deadline, it is still ripe to be heard in my review. But however, although I do understand your argument and I do understand the supporting argument with Ms. Perrin, I am denying your motion based on State v. Cameron. I know that it may be undecided or nothing set in law, federal versus state, but State v. Cameron, at least in my court, that is what dictates, and that's what rules. And this will be an argument for the jury. And that's where you can present your own witness. I'll even permit the defense to find and locate an expert to testify at the speedy trial, even though my scheduling order states that an expert report must be submitted within 30 days prior to trial. I believe that in a case like this, and having the witness that the state has with the arguments made by defense, if by chance you happen to believe that you find an expert or even another lay witness that can testify, a report can be provided along with the deadline for the witnesses. And in my view, I do understand that there is a holiday, that there is the Thanksgiving holiday there. But in my count, I can see, unless objection by the state, that a deadline for witnesses and or then any report could be November 21st. Granted, it doesn't give much time for everybody to be prepared, but then I believe it's more fair to the defense to be able to find another witness if you wish, or to be able to, then as of today, what questioning you can line up to question Ms. Britton when she's on the stand to cross-examine her and her knowledge of the mapping as well as the other issues as you see related to that data.
Judge, I just want to, I'm sorry, it's not appropriate, but I just want to, so she's not been disclosed as an expert. Her credentials have not been.
She is not an
set
expert.
forth. And so I would just argue to bring forth the information that's required. I mean, I can ask her the questions, but our position remains this should be handled differently. Thank you, Your Honor. I appreciate you really.
And you can, and I understand where you're coming from. You're free to ask her whatever questions you would like to ask her while she's on the stand. But in my reading of State v. Cameron and in the analysis, I don't find her to be an expert witness, again, according to what the parameters of State v. Cameron. So that's where that is. Mr. Schmidt, is there anything you would like to state with regards to my order?
Just if either the defendants plan on retaining an expert, that'd be the only circumstance in which I would get an expert. So I just ask if they do plan to do that to let me know ASAP, and then just whatever the court's deadline for the defense apply to me too. Because I assume these are both public defender cases, if that timeline is not possible because of how the public defenders do their expert retaining things, let me know ASAP.
Well, and here's the thing too, and I'll throw this out there. I know that this has been requested as speedy, and I can't remember if it's Mr. Actorling or Ms. Actorling that requested the speedy. However, that if this is such that in discussion with your counsel, you believe that you really want an expert, and that is something that you wish, even though this is the final pretrial, I will allow you to withdraw your speedy, and we can get it set for another very quick turnaround for a trial. But I want you to be able to be prepared in presenting your case, because this is a very serious case with serious charges and potential serious ramifications. So I would allow you to be able to do that without any penalty or anything of that nature, okay? So I don't know. I'm seeing some discussion between Ms. Actorling and Ms. Perrin. I don't know if that means you would like to have discussion amongst the four, although you're completely separate cases, separate paths, and separate wishes and desires. But
could we just have just a very brief moment? And it won't be, I don't know how long does the court have? Are you able to give us a few minutes?
I'm running way past and past calendar. But here's the thing. Even though I do not like to do that, I'm not other courts. I do not like to do that. This is a serious case, and I want the defendants to feel comfortable in proceeding, because I'm going to be blunt. Your lives are on the line, okay? Serious case. So I want you to be able to feel comfortable in where you are here today and where you are with your attorneys, okay? And where you are with the facts and the evidence and the witnesses that you have. So I am prepared to be able to leave and have everybody else vacate the courtroom, and except for law enforcement, I cannot have him vacate. But can you please raise your right hand? Do you swear to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Anything and everything that you hear inside this courtroom that pertains to this case, you are not an attorney. But do you swear that you will never, ever state anything of what is said in this case at all? Never, ever?
Never.
All right. So that's the best I can do. I'm sorry. So I will excuse everybody for a brief moment.
Can we just say
back.
10 o'clock?
10 minutes.
I can give you until 10 o'clock.
We'll take 10.
I'll give you until 10 o'clock.
Okay.
Yes. Back on the record, same appearances as previously noted. The court has allowed attorneys Perrin and Erdman to have a confidential conference with their clients, Mr. Actorling and Ms. Actorling. Again, for the record, we did have law enforcement present in the courtroom during that time. He was placed under oath, and he was sworn to keep everything confidential, and he may not disclose it to anyone or there could be contempt of court, yada, yada. All right. So, Ms. Erdman, do you want to update the court right now, please?
Judge, I am not signaling in any way, so we should all keep preparing as we have been. But I would ask the court just for, until maybe mid next week to extend the settlement deadline. I am not saying I'm not signaling. I don't want anyone to read anything into that.
No, nobody's reading anything into that. And I'm gonna tell you, I'm a judge. I like to stay on time and I like to stay with my deadlines, especially with speedy trials because they are quick, and everybody has to do it quick. But with that understanding, knowing that this is something that's going quick, and both of the defendants, you have a lot on your shoulders right now. You have a lot to think about, a lot to digest. I am willing to extend this deadline to next week. No objection? Do you have an objection?
No objection. If you need to contact me, I'm at SPET next week. So just contact my office. I'll get you my personal number and be available.
And that's what I was going to say too. I am at a all judicial conference next week, but I will still be reached by all of my staff. And so I will be able to be up to speed on what's going on. We have Veterans Day. I don't know if you probably work all the time. So I remember private practice too. You work all the time. How about a deadline?
I think Attorney Perrin and I are both going to Milwaukee on
Wednesday.
Thursday, and you're leaving Wednesday.
My thought was deadline by Wednesday.
Okay, perfect.
Does that work?
Yep.
Because then it works with, so we all are going to conferences. Yay! No work in courts next week at all. Yeah, so deadline by Wednesday. And can I say Wednesday by noon?
Sure.
Does that work?
Yep.
So Wednesday by noon, okay? And so you'll update the court, you'll let me know. And if I'm going to, it's probably going to have or need a response by the court, but you'll get a response even though you'll be in a conference, and then you can let your clients know, call them if necessary. Otherwise, we can set a hearing by Zoom on the 17th if you wish.
We'll cross that bridge if we need it. We'll set something up with Madam Clerk or.
So you know, my afternoon has cleared on the 17th, so I could pretty much facilitate anything on the 17th. And I'm just gonna throw this out here. Okay, I'm just gonna throw it out here. I'm taking no implications that there could be a settlement, none implications. But if by chance it does, and it can, if it will, or whatever, again, I'm open all afternoon. I have all afternoon. We can argue, we can do a plea.
I've got another speedy trial that I believe is going forward in Polk County that day, but again, we'll cross that bridge and I will try to be as prompt as possible with the court so that we can figure something out.
And well, if you have a speedy that's going that day, I know that it's hard when you have a trial to fit things in. We could even possibly facilitate at 12.
Yeah, right.
Something.
I appreciate your Honor's flexibility and we'll stay in touch.
Okay. All right. Did I have a victim say something? I'm muting the victim because the victim keeps making noise, or whoever's identified as a victim. Okay, anything further we need to address, at least at this moment, Mr. Schmidt?
Are you withdrawing the thing about the late discovery DNA?
Yeah, Judge, I filed some motions in limine. I can kind of go through them quick, but I don't think any of them are going to be really long. Number one was a DNA discovery question. I actually am in possession of what Attorney Schmidt acknowledged to be the test. I think it'll be subject to cross, something ripe for that.
Okay.
So I'm not raising issue, and I will say the state was prompt in their disclosure.
So that's withdrawn. Okay. And then you had one about Facebook messages or something.
Yeah, the next thing that I think, it's more probably of a heads up. I tend to try to err on the side of getting things before people so they can think about them, state court, myself included. And so we've received downloads, and I'm talking, and law enforcement's paged through them, but I don't even know if they were able to get through everything. There's a lot there, Judge.
And I'm going to interrupt you. I don't know what's all there. I don't get discovery. So I don't know how voluminous they are. I know the ones that have been brought to my attention through motions and those things. Those ones I didn't have issue with coming in. I don't know, again, what's particularly in the other massive communications.
Okay, I'm assuming Your Honor's referencing the things that were disclosed in the complaint, right?
That must be it, correct?
Or did Your Honor get information outside of the?
I'm not, either this or Mr. Harrington represented Mr. English, and we had a very lengthy motion hearing in that case too, and I don't know if additional ones were provided in there or not. No, Mr. Smith is indicating no. So whatever was provided in the criminal complaint, that's what I'm referring to.
Okay, so I guess, I mean, I'm just making note today. There are things where law enforcement is saying in their report, I reviewed this information. This is hypothetical. I saw a picture, a photograph of Mr. Actorling. In the same photo was a purple dress. I know a purple dress was taken from a house. It could have been one and the same. Those kinds of things where there's speculation involved.
Well, it's speculation, but open to cross.
I believe that unless the state's here prepared to say that the only cases involved were those that are in the state of Wisconsin. These are Minnesota, or Mr. Actorling lives in Minnesota. Things were located in Minnesota. I mean, I think some of this is potential for other acts, right? So there's a trailer that was located. We don't know where that's from. But to speculate that it was from this, or to somehow say, you know, things involving drugs or something to that effect are relevant.
That is definitely not relevant.
But I think we can address that. I know Your Honor's got a lot going on. So those are just kind of a heads up. I don't have anything specific listed intentionally, just kind of making everyone aware. I view that as other acts. I think that there's, you know, nothing that's been brought before the court saying we intend to build the case that because there's other things that are likely stolen, perhaps stolen from other instances, that they're somehow relevant here. I think the rest of this, Judge, is boilerplate. I tried to underline the things that were kind of unique to this case.
Was boilerplate.
So
Yes.
That's all I have.
That's all I had highlighted. Mr. Smith.
Oh, I'm sorry.
Oh.
I have one more final thing. This is kind of an add-on. My expectation, or I guess my hunch, is that Mr. English is prepared to manage his case with a plea. If so, I would ask that all of the plea negotiations, including the disclosures that he's made to law enforcement, be made available to us immediately or as soon thereafter as possible, and that all benefits of any bargain are also disclosed. That's the last thing.
All right. I have not had Mr. English's pretrial yet, but we are going to have that not right after this. I have to jump into the quick cases first before I bring them down. Mr. Smith.
Just, I'll comply with what they asked about Mr. English. On the Facebook, if we did a Facebook subpoena, it was only the relevant time for the burglaries. There is drug stuff in there. I don't intend to use drug stuff. I only plan to use stuff related to stealing or preparing for burglaries or talking about burglaries. I am not aware of other burglaries Mr. Actorling has done. I think they're all related to these. If Ms. Erdman thinks that there are statements in there about burglaries or thefts or related to that are related to different burglaries, I need to know what specific statements they are different burglaries, because I would have no way of knowing. Thank you.
All right. And I
would just argue that if they're not clear enough on their face that they're related to a particular case, then they need to stay out, because we don't, if I have to try to get, or if he's
here's the
trying
thing,
to guess.
you can look through them, you can make your argument as to what, but again, this is an other acts which should have been done a lot prior to today, and we should have had the arguments and hearings prior today. I am giving an additional week for the settlement discussions, or to update the court as another final pretrial or whatever. But if there are particular ones that you don't think are clear, you can point them out to the court, and the court will make that determination. And I know other acts, and I would know the factors and the test, and we can go boom, boom, boom. That can even occur right before the trial, if that's what we're going to do. Okay, Ms. Perrin?
Your Honor, part of my motion limiting is asking the court for an order that no other acts be allowed, because the state has not filed any motions on that. So I just want to mention that, since the issue has come up.
No other acts, correct, but we'll get into the convictions and whether all of that. That's kind of boilerplate, kind of the thing, because we haven't gotten here, but Mr. Smith.
And that's what I'm just trying to get into is, I don't think any of it's other acts. I think it's all related to these burglaries. I have no information of them doing other burglaries. if I did, they'd just be in the complaint. They wouldn't be other acts. So I don't think if that is their position, I need to file another X motion because it sounds like they would be contesting my position and saying, no, these are not messages our clients talked about doing these burglaries. This was them talking about doing other burglaries, which would be on them.
I fully understand both sides here and your arguments. And Ms. Erdman, because we have this additional week, I know it's putting a lot upon you and Ms. Perrin too, because I'm going to guess it's a joint. But to look at those text messages, and if this matter has no chance of resolving, then point those out, your deadlines by next Wednesday as well.
I'm just gonna say that's impossible. Like, we've got 3 other speedy trials and it's not our burden, and they can come in at trial and then we'll object.
But it's my burden. It's my burden.
That's
I have to
why
decide.
Let the court
Then
know
give
ahead
them
of
to
time.
me. Then give them to me.
Okay. Well,
Give me the text messages. I will review them. Give them to me.
That's why my motion, I only just asked, which messages are you saying? I don't know.
Because I don't know. I only have the messages in the criminal complaint.
in the-
You want me to make a decision and to decide? I can't unless I have them and I have arguments. And I need defense to give the ones to me that are questionable. Otherwise, give them all. And then
the
I will
state
review
could
them.
perhaps just disclose what they intend to use and we could go from there. I mean, that way we're not guessing like we've been with the Daubert motion and everything else.
I'm using all messages which they talk about burglaries or thefts. I think they're only talking about this cases. I have no information they're doing other burglaries and thefts around the same period.
The trial may take 3 weeks then if you're using all messages, just putting that on the
Well,
record.
I'm gonna tell you, I am some trials may take 4 days in one county. You only take 2 in mine.
Right. Understood.
Okay. Anything else? And again, I will state on the record though, I have no problem, and I'm not the jury. So let the defendants know, I'm not the jury. The only way I make a decision on these text messages or Facebook messages or whatnot is whether or not they can come in or not. I don't decide whether or not, you're guilty or you're not guilty or all of those things based upon text messages. So that's why I'm just putting it out there. I have no problem. You want to know what? I have 4 days of, granted, lots of conferences, but I have lots of downtime too. I have lots of reading time. I usually bring the Court of Appeals cases and read them all through there. So I will have time if that's what you would like. Just putting that out there. Again, another thing for you guys to talk about. Okay, we got to wrap this up though. Any last? All right, then we are adjourned. Thank you.